The MPP leadership decided to challenge the outcome of the 2012 presidential election in the Supreme Court. The questions that exercised our minds are: why was the swearing-in of President Mahama not delayed until the outcome of the election petition was known? Secondly, is there a time limit for how long the Supreme Court should take to decide on the election petition? Number three, what will be the implications of the Supreme Court's decision, whatever it is, on the tenure and exercise of the powers of the President of Ghana? But lastly and most importantly, what do we have to do to ensure that this eminently avoidable mess that we find ourselves in today will never be allowed to happen again? Whatever your take is on this election petition, it is my hope that when we are done, you'll be better informed. So you either share or even vehemently oppose Tarzan's take. But most importantly, what we all ought to be able to do at the end is that we'll become enriched and inspired to do what it takes to ensure that the current crippling situation and the uncertainty will never occur again. We'll take a break at this time, and when we come back, I'll introduce my guests who will inform you most eloquently and eminently about the subject matter. But before we also will take the opportunity to enlighten you a little bit by sorting out the wheat from the chaff as to what is happening in the Supreme Court. See you soon. Welcome back. I told you that this program will be different. You hear my provocative views, but we want you to be absolutely well informed. I have two people with me here who could not be better at this game. My first guest is one of the few people who at almost 90 knows exactly the hour at which he was born. 4 o'clock on the 23rd of October. Justice V.C.R.A.C. Crab. When we were in school, we used to remember those initials. He's been a Supreme Court judge in Ghana. He's Ghana's first electoral commissioner. He wrote the 1969 Constitution. He wrote the 1979 Constitution. That Constitution is almost word for word the 1992 Constitution. There's nobody better qualified to speak on the Constitution of Ghana and the laws of the electoral process. Welcome, my Uncle Ogoto.
Thank you.
You're welcome. My other guest is politician, lawyer, constitutional expert. I first met my other guest maybe 20 years ago when we were all involved in the political process. He rose from the junior ranks to become the General Secretary of the People's National Congress. He is now the board chairman of the Center for Public Interest Law. But here, he's here because he was a member of the Constitutional Review Commission established by the late President Mills. Welcome, Gabriel Puaman, and thank you for joining us.
Thank you.
Before we start our discussion, we want to spend about 10 minutes introducing you to what the reality is. Why are we concerned that the Kenyans beat us to it? We want to sort the wheat from the chaff about the electoral politics of Ghana and the politics of electoral petitions. Please stay and join us.
On Sunday, December 10th, the chairman of the Electoral Commission, Dr. Kojo Afarijan, declared John Mahama, the presidential candidate of the National Democratic Congress, as the winner of the 2012 presidential elections held on the 7th and the 8th of December.
Based on the results given, I declare John Dramani Mahama president-elect. Thank you very much.
Within 28 days of the announcement, the opposition New Patriotic Party announced that it was going to challenge the result of the presidential elections in the Supreme Court in line with the requirement of the 1992 Constitution. And the Constitutional Instrument 75, which was put in place to guide the conduct of the 2012 general elections, Article 64 of the Constitution states that the validity of the elections of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of the elections in respect of which the petition is presented. The Rules of Court Committee shall, by constitutional instrument, make rules of court for the practice and procedure for petitions to the Supreme Court challenging the election of the president. On December 28, 2012, Nana Akufo-Addo, presidential candidate, Dr. Mahmoud Bawumia, vice presidential candidate, and Mr. Jake Obechebi-Lamte, chairman, respectively, of the opposition New Patriotic Party, filed a petition at the registry of the Supreme Court challenging the declaration of John Mahama as president of Ghana. On January 7, 2013, even before a date had been set to hear the election petition, the Chief Justice of Ghana, who presides over the Supreme Court and indeed the entire legal system of Ghana, swore John Mahama into office as the fourth president of the Fourth Republic of Ghana.
I, John Dramani Mahama,
do in the name of the Almighty God swear.
Do in the name of the Almighty God swear.
That I will bear true faith.
That I will bear true faith.
And allegiance to the Republic of Ghana as by law established.
And allegiance to the Republic of Ghana as by law established.
For many people, swearing the president into office before the outcome of the election petition was the wrong way to go about it. Unfortunately, however illogical it may seem to them, the Constitution of Ghana did not specifically bar John Mahama from assuming the office of president ahead of the determination of the election petition. Rather, foreseeing the potential confusion of the situation, the Constitution simply tried to avoid a vacuum in the governance of our country by stating that any action taken by the president right up to and including the moment if the Supreme Court upheld the petition would be lawful and binding unless changed subsequently. A declaration by the Supreme Court that the election of the president is not valid shall be without prejudice to anything done by the president before the declaration. On April 17th, 9 members of the Supreme Court started hearing the election petitions. However, even before it had been able to start hearing the substantial petition, the Supreme Court of Kenya had heard and pronounced on the petition filed by the losing candidate of the presidential elections, Raila Odinga. Two things stood out from the Kenyan experience. Firstly, both their elections and subsequent petitions took place well ahead of ours. Secondly, swearing in of Uhuru Kenyatta as president was delayed until the outcome of the petition was known. Naturally, many Ghanaians felt aggrieved and suspicious about the Kenya experience in relation to the confused situation and slow pace of our own action. Comparisons began to be made, and the motives and commitment of those adjudicating our actions were called into question, albeit without a shred of credible evidence. In our haste to condemn, we seem to have forgotten that those who preside over legal dispute, whether in Kenya, Ghana, or anywhere else, where the rule of law prevails, can and must only do so within the bounds of the established laws and norms of a country. Therefore, Kenya spurred on by need to avoid the terrible tragedies that befell their previous elections in 2008. Their parliament passed a law ahead of the year's elections to guide the conduct of any petition that may arise from the elections. The Supreme Court's Presidential Election Petition Rules 2013 required that a petition must be filed within 7 days of the declaration of the result by the IEBC in the Kenya Gazette. The hearing shall commence within 2 days of the pre-trial conference, and the petition must be heard and determined within 14 days of the date of filing. There is no right of appeal. The determination of the Supreme Court is final. In contrast to the clear, decisive, and quick Kenyan process, our laws merely state the 21-day period for filing a petition. It is totally silent on how long the process should take, nor indeed if the decision of the Supreme Court can be subjected to the normal judicial review allowed for under our Constitution. Unfortunate and unacceptable as the situation we find ourselves in, this is the law of Oman Ghana, and we have seen already we are in a very long haul and coming to a conclusion on the ongoing election petition. This is a real pity and a slap in the face of the people of Ghana by those politicians they have entrusted their powers to. The situation has been brewing since the start of the Fourth Republic, but those that should have done something about it chose to bury their heads in the sands of selfishness because they believed they could use the confusion and lack of clarity to their own parochial partisan interests. In 1996, the MPP parliamentary candidate for the Ayawaso West Wuogon constituency in the Greater Accra region filed a legal challenge that his opponent, Rebecca Adote, has stolen the elections and should be prevented from holding herself up as an elected member of parliament. In consonance with the law then, and still in place now, the disputed winner, Rebecca Adote, took a seat in parliament during the hearing of the petition. Unfortunately, it took nearly 4 years for the court to uphold George Amu's petition, by which time the parliament that he should have been a part of had only 1 more week of tenure. The MPP went on to win the general elections of 2000, and John Agyekum Kufuor became the president of Ghana, with Nana Akufo-Addo as his Attorney General and Minister for Justice. Today, Nana Atudazi and Chacho Chikata, Chief of Staff and Brain of State, respectively, of the PNDC, prime movers and shakers of the 1992 Constitution, are striding the corridors of the Supreme Court, exchanging legal fisticuffs on the legitimacy or otherwise of John Mahama, who already assumed and is exercising the full powers of the President of Ghana. It is my contention that Amu's misfortune, coupled with a seeming rush of the rash transitions of 2000, because of the need for a second round of voting, should have sounded alarm bells in the ears of our politicians, foretelling the big mess that took 13 years to germinate and has come to agitate and disturb our peace and tranquility today. In the run-up to the return to democratic rule, and ever since then, each political administration has simply sought to twist and turn the confused and illogical electoral laws to its own pecuniary advantage. Electoral issues that in opposition were deemed to be in the public interest were forgotten and, more seriously, subjected to the whims and caprices of personal and partisan interest, to the dictatorial powers of political office. The incessant creation of new districts, the failure to take initiatives to correct the obvious gaps in the electoral laws, the resort to transitional bill, and the fudging tinkering of keeping the material property rather than addressing the meaty substance of serious electoral reforms, and the crass insensitivity of the political class ganging together to chew on the bony carcass of Ghana's public funds are all but glaring and unacceptable examples of our politicians putting their personal greed ahead of the public good. It is my take that, whatever the outcome of the current petition, I say a plague on the houses of protagonists. Ghana deserves better. And the most important outcome for the people of Ghana is not who wins or loses the case, but what we do to make sure that whatever changes must be made to the electoral laws must be done ahead of the next general election in 2016.
Welcome back. There you have it. We've tried to contextualize what is taking place in Ghana by sorting the wheat, the substance from the chaff, by talking about what is the reality rather than what we would wish to happen. Because it's important that when we do talk about these matters and give our opinions, it must all be founded on the law of the land and what it is we can and cannot do. And that is why I'm so pleased to be joined by two people tonight who will take us back to the beginning, but also bring us right back up to the front. Let me start with my uncle here. You are virtually the doyen of constitutional writings in Ghana, because apart from the first Republican Constitution, you've been at the heart of the Constitution writing for the second, third, and fourth republics. Can you tell us what were the discussions about matters of disputes? Did these ever come up, and how were they handled?
I think the first thing we have to understand is the nature of constitutions. Constitutions are written for a people, by a people. And in writing a constitution, you take account of the political aspirations of the people. You take into account the historical antecedents of the people before you get to what becomes the legal document which we call a constitution. So every constitution is historical in content. It is also political in content. It's also a legal document.
Yeah.
If you take constitutions over the world, you will find that what I have just said belies all the constitutions. Take, for example, the American Constitution. They had a fight with a monarch about the powers of Parliament.
Yeah.
The cry was no representation, no taxation. So you will find that when you take the American Constitution, the first thing they have dealt with is the powers of Congress, because they were dealing with a parliament which was far away and was containing them. So when you are looking at constitutions, you have to look at these three aspects of the constitution: the political, the historical, and then the legal. Now, what's our history in this country? We had been for some time a colonial people. We fought for independence, we got it. We had an independence constitution. Within no time, we changed it into a Republican constitution. That Republican constitution lasted for about 6 years.
Yeah, that's right.
We had another constitution. It lasted about
27 months, I think. The second one, yes.
Then we had another constitution,
which also lasted 27 months.
So you see, in our political history, the constitutional context in which we write constitution has all changed. And we have got to take into account all these antecedents when you are dealing with the constitution which we have now. We've just been talking about the election of the president and why in Kenya they have been able to finish their problem and we are still dealing with our problem. If you take the history of Kenya into account, you'll appreciate the bloody consequences of the elections which they had before. What went on is terrible. And I believe I'm right in saying that even the person who has been elected as president of Kenya is at the moment
in court
facing a charge before the international.
But I think the interesting thing for me is that the Kenyans, out of the experience of the last 5 years, did something about it. Now, what one could say that, for the first, the second and third Republican constitutions, I think it would be interesting for us to know whether you, as one of the people who were at the heart of it, I know in the second Republican constitution, the powers of the president were not, or in fact the election of the president was a different procedure. But the 79 in the current constitutions are virtually identical in terms of the election of the president.
Yes.
Was it foreseen that there would be a challenge? How was the discussion, and why wasn't those constitutions very clear and firm in these positions?
If you take the present constitution, it's quite obvious, as was said earlier, that the constitution takes into account the possibility of a challenge of the election of the president. And that's why the provision is there that if the president is sworn in and it's challenged, then anything the president had done before the challenge is constitutional and legal. So the Constitution itself anticipated that this type of situation was going to happen.
But for most,
and it did happen.
Yeah, but for most people, they would have thought that if there's a problem, why don't we solve it before we let the president take office? Well, I mean, what was? I would like you to share with us the flavor of the discussion that said, "Oh, let's go ahead and deal with it when it happens."
You see, we are dealing with that situation now because you have the Kenya experience.
Yes.
When the Kenya experience was not there, nobody thought that would be in the position in which we are at the moment. But as I said earlier, the Constitution instead anticipated the situation when this challenge will come.
Okay,
and
let me
because
just bring in,
of our circumstances.
Let me bring in Gabriel, because you are very active in the 1992 Constitution, because you were a very active politician. And the PNC participated actively and took its seat in Parliament. And I remember, apart from the Amu situation, there was a Woolensee case as well. What did you feel about those provisions as a working politician working with the 1992 Constitution?
Of course, thanks very much. I think the issue about how quickly we dispose of electoral disputes is an issue that has been of concern to Ghanaians. And as you are asking, it's an issue that has not been very satisfactory. But the issue has to do with the actual practical implementation of the provisions of the Constitution. Because we are dealing with a situation whereby when we are doing the Constitution Review Commission work, we receive submissions as to how do we deal with the delays. And the delays that are coming have to do, number one, with the rules which are applicable, number two, with the timelines which have not been put in place. And this discussion has been ongoing, and I don't think it is fair for us just to jettison all that is in our Constitution as if what we did, we got it wrong. At the time we were doing the Constitutional Review Commission, which was just 2 years ago, we took comparative analysis of what is in other countries. And the practice that we have in Ghana is what most of the common law countries are using. Nigeria is the same provision. In the US, it is the same provision that in order to have an election petition properly determined, there are two critical factors. While you are talking about expediency, you are also trying to look about fairness. That the people who will come with the complaint, they want to have a fair hearing, because at the end of the day, there will be finality of determining the matter. And this is where the problem is.
But the U.S. experience, especially with George Bush in 2000, was the fact that it was determined ahead of the swearing in of the president.
Yes.
I don't think anybody is suggesting that there should be, if you like, a process which doesn't recognize. But I think for most people, the really challenging thing is why a president should be inaugurated ahead of the dispute being settled.
I'm very glad you've raised this. If you go into our constitutional history, I believe the 1992 Constitution was subject to a referendum.
That's right.
The people who are talking now and raising these issues, what did they say when the thing went to the referendum? What did we say when it was before Parliament? Nobody said it. It's because we are now faced with the reality of the situation. And something else has happened somewhere. So we're making a comparison.
I don't think so. I think even though I am much, much younger than you are, what I remember about 1992 constitutional referendum was it was a take it or leave it referendum. You were not allowed, if you objected to any particular feature of it, the whole thing would go.
I agree entirely with you.
So we were not given any opportunity to express our views on what we disliked and what we didn't dislike about it.
I entirely agree with you.
But I also suggest that having had the Amo experience from 1996 to 2000, and then the Woolensee experience, I would have thought, and coming back to a recent comment you made, that it was in the collective interest of all the political parties to say, well, how do we make sure it doesn't happen in 2004 or 2008? I think we should have been anticipatory.
Well, the politician is sitting down there.
No, it's not a question. I think the part that I want to come in is that yes, the point you are making is correct. And we have actually done something about it as a nation. Yes. In the course of the Constitutional Review Commission's work, this was an area that came up very strongly. And there are specific recommendations from the Constitutional Review Commission which will deal with this problem. Number one, we have an issue whereby, by the provisions of the electoral laws, the date of the election is just 1 month before the president has to be sworn in. But so the recommendation has been that let's shift the date of the elections then we have a space of 2 months. That will be sufficient for us to deal with matters of this nature before.
But some people argue that November 7th is not cast in concrete. I mean, I'm not a constitutional expert. But can somebody clarify that for us?
Yeah, I'm going to do so.
Yes.
You see, the problem is not with the Constitution.
No.
If you look at the Constitution properly, it says the election of the president should take place within 4 months before the president demits office.
Right.
In respect of the general election, is 30 days before Parliament is dissolved by the Constitution. What happened, I'm told, is that the politicians agreed that we should have both elections on the same day. And that's why we are having it on the 7th. If we had listened to what the Constitution has said, that have the elections of the president within 4 months before the president exits office, and then you wait for your 30 days before you have the general election, the problem we are in at the moment would not have arisen.
You see, I'm in the midst of two eminent constitutional lawyers, but please educate my layman's mind. In other jurisdictions, the elections for parliamentarians and the Senate and things are held. For example, in the United States, elections will be held on the 4th of November. The Senate and the House of Representatives of the old will continue to function until the end of the year, before a new one takes over. So I am not too sure whether what is the dissolution of the Parliament necessarily fixes a particular date. It simply says one must take over from the other.
No, our Constitution provides that the Parliament comes to an end at a specific period.
That's right.
The Constitution states that. Mm-hmm. The Constitution also says, and I'm going to repeat it, that you have the elections of the president
4 months,
4 months before. And then the election to members of Parliament is 30 days before
that
Parliament
is stated in
comes
the Constitution.
It's in the Constitution clearly.
Okay.
So the problem we are facing is that we brought both days together. The Constitution never said so. I believe it's the politicians who agreed that you'd have both elections on the same day.
That's a human factor.
Because the argument I thought was that if you have the elections of the president first, the party which wins are likely to influence the general election.
Naturally, people want to be with the...
That was the rationale behind it.
So
let me finish.
Yeah,
I don't see why the Constitution is now being blamed in the situation in which we are at the moment. Those who are responsible for having the elections on both days are the people who should carry the blame, not the Constitution.
I don't think anybody is blaming the Constitution. I think the real issue is why we have waited for so long to take action. I think that's really the issue, because clearly in 2000 we could have taken action. But since you've raised this matter of the Constitution, Gabriel, tell me, how did the Constitutional Review Commission get around this issue of making sure that we give ourselves enough time to deal with potential petitions, as well as the stipulation of 30 days we must... How did you do with
No,
that?
what we did was this, and I think I am still of the view that the policy of having both the presidential and the parliamentary elections on the same day is very, very important, because to avoid the bandwagon effect, as Justice Crabbe is saying. And we experienced this in 1992, and that is why, as a nation, we all agreed that it is better to have them the same day. So what we did at the Constitutional Review Commission is that, why don't we now amend the provision of the Constitution which has to do with the period for the holding of parliamentary elections, and extend the time from the 30 days to 60 days. That will enable the Electoral Commission to fix a date for the elections, which will be in November.
Okay.
Now, if we have a date in November, and the elections are held in November, and there is a petition, it is conceivable under the current rules of the Supreme Court for dealing with electoral petitions that it could be resolved even before the president is sworn in, before you have 2 months. So if these provisions, these recommendations, which have actually been accepted by the government, are implemented, this matter will be dealt with, I think, in a fundamental way.
But were they accepted? Because I read the white paper that was issued by the government, and it was completely silent on that particular matter.
Yeah, what the white paper said was that where the white paper is silent, it means that they have accepted the recommendation. So,
but they're very vehemently pro other things.
No, but what the starting line was that if the white paper does not express any opinion on a matter which has been recommended by the Constitutional Review Commission, then it should be deemed that the white paper accepts that recommendation. So that recommendation stands accepted.
But surely, I mean, there are two issues here. First of all, the government that published that white paper is no longer in power. So what is the position of that white paper? But before I go to that, let me go back to justice. Gabriel says that the current rules would allow. As a layperson, I don't see it that way. The only thing I see is that you've got 21 days, but in which time you can file a petition. But unlike the Kenyan situation where they stipulate that a decision must come to within 14 days, we have no such provision in our Constitution. Can you enlighten all of us on that?
You have just said that it says within 21 days.
Yes.
You can do it immediately after the election.
No, because Gabriel raised the point about the current rules allow. But I'm saying that the current rules, as far as I know, because in fact a lot of people, when the MPP first went to court, expected that the matter would be dealt with within days. Before it dawned upon them that no, the 21 days only apply to the time by which you could file your petition.
But that is because the petitioner decided to file the petition on the last day.
No, I'm not talking about when they decided to. See, right now, I research Kenya, and Kenya says from the day of filing, 14 days, a decision must be taken. Yes. We have nothing like that in our Constitution or in our rules.
What our rules are saying, you know, in 1996, we after this Constitution, the 1992 Constitution came into force, we published the Supreme Court rules, and there are rules there concerning the electoral petitions to challenge the president. But after 1996, these rules were reviewed by the judiciary itself in 2008. And that was when the timeline, which is already in the Constitution, said that you are right to file the petition within 21 days. The rules cannot do anything about that. But the rules say that once the petition is filed and served on the respondent has 10 days to respond. After the respondent has filed his response, if within the 10 days, then the court will now fix and have a determination of the matter 15 days from the date of the final service, 15 days.
But, you know, the issue for us lay people has been all these interlocutory issues that have been raised. You see, Gabriel, my simple layman's view of this whole thing is that I read the Kenyan law, it's clear. 14 days from filing, there must be a decision.
Yeah.
There's nothing in our Constitution that provides that kind of stricture.
Yeah, Charles Bros,
yes.
the challenge which all constitutions have is how do you balance fairness against expediency? And there are problems. You see, we're taking the position as if the Kenyan thing has not been with problems. If you read closely the Kenyan experience, while the matter was in court, other evidence was discovered which was brought to the court by way of affidavit, but the judges said, look, we are time-bound, we cannot entertain it. A question can be raised as to whether it is fair that if any discoveries are made after the date that you have filed, and the Constitution has fixed the date, how fair is the process? And that is what I'm saying, that we are trying to do a balancing act between being fair to the person who has brought a petition and also going on the side of expediency. And this is why in other jurisdictions, what we are practicing, we are not the only people practicing it. And as I'm saying, the court itself has reviewed its rules and tried to take a posture that 10 days, when you are served, 10 days you should respond. And then they have 15 days to do the hearing. And there's also a timeline in the current rules which says that after the hearing, 15 days, there must be judgment.
Okay. Judge.
Yes. So you see, we in this country have also taken steps to deal with the situation in our country. And I'll say this and I'll say it again. It's not right to compare the situation in Kenya with the situation here. As I said earlier, you have to take into account the circumstances which had led to the reading of our Constitution. We have got a legal process here which allows time for people to bring in their case. As Gabriel just said a little while ago, after they've given the decision in the Kenya case, certain issues have arisen. If those issues had been before the court, would the court have come to the decision to which they came to? It's for us to also answer that question, which people seem not to answer. In our situation, we've made the road clear as much as possible so that there is fairness, and you'll find that Gabriel keeps on hammering upon the fairness of our situation as to the unfairness of the Kenyan situation.
No, well, you see, okay, let me play the civilian in all of this.
Yes.
Fairness must go with some logic. If you talk to every Ghanaian, I would say 90% of Ghanaians will tell you that the situation where you swear in a president ahead of a determination of a petition whose time is and tenor is not known is inherently dangerous to the governance of this society.
How is it dangerous when your constitution has given you what you have?
The constitution is a living document. So moving forward, how do we address this issue where clearly there's an overwhelming majority of the people who say, whatever you have to do, and you are the clever people, whatever you have to do, we don't want a situation where an election petition is held post facto after a president has been elected.
Now, we have given you the answer. The answer lies in the amendment to the Constitution.
And bringing
so that you hold the elections in November.
Yeah.
When you hold the elections in November and all this takes place, the court's case will be resolved before.
Not necessarily. What about these interlocutory things which have spent 2 or 3 months?
Charles, I think let's be fair to the Ghanaian process too.
Yes.
The reality is that filing an election petition, it is not just a very simple matter. You need to be sure of your facts. You need to investigate. Take, for instance, we had an experience in 2004. After the elections in 2004, the NDC appeared to have some complaints. They were not able to get their information within the 21 days. So it was after the 21 days that they got certain information, and then they went to court. That case is Metal Nunu versus and 2 others versus the Electoral Commission, 2005, that they filed it. Now, when they filed it, it was clear that they had certain information, but it was late. It was after 21 days. So they now went through a legal process of saying that the constitutional instrument which declared the president should be set aside, but the court looked through it and said, look, this is an election petition.
Gabriel.
So the practical things that I'm trying to make is that in our system, these are the practical things. If we shift the date backwards to the November date, then the problem that we are talking about the swearing in can be dealt with before the swearing in.
Practicality and perfection don't go together. If we say we are looking for perfection of evidence or perfection of process, then I can't see how, because you see, I see the 2 things, and you have to advise me through me and Ghanaians as you are the experts on the matter. The issue of pre-trial...
there's a pre-trial conference. Which settles the issues and gives directions as to how the petition is going to proceed with.
But that in our case happened after 2 months of a lot of interlocutory. Is that a word? Interlocutory.
Yeah, interlocutory matters. No,
whatever it is.
I agree with you that there's a way in which it is possible to curtail and reduce those matters. And I think the court itself has taken a position on trying to curtail delays and trying to make sure that the matter is dealt with dispassionately. But I would still emphasize that the court is also cautious about trying to be fair to the party. Say that at the end of the day, a party cannot complain. Charles, let me give you an example. Summary proceedings in election petitions is a matter which is engaged in countries, not only Ghana. If you look at the Nigeria example, Nigeria, 2005, there was a petition. 2009, there was a petition. Almost every election, they have electoral petitions. They filed a petition. It is gone into, and they also have a provision whereby the president is sworn in and the determination comes later. I don't think their state has collapsed on the basis of that provision.
No, I think there's a problem. You see, there's a problem here. The longer the duration of these things, in my lay view, the more secure the tenor of the person who is there, as the matter goes on, being delayed and delayed and delayed.
No.
Well,
I think Justice Cram will tell you
if
that.
you look at the Nigeria situation, in the 2 or 3 situations that the matter has been determined, you look at the decisions. And what was the decision? Yes, we found some problem insufficient to do this. I think what we're looking for...
But the Kenyan one was short and they came to the same conclusion. And I think that it is not fair to say that anybody as a judge of the Supreme Court is going to be persuaded by the fact that the person has been protected by the Constitution. These are people who are very well experienced, and there are people who would look at the evidence and come to a conclusion based on the evidence. So and I think we are too quick to throw out what we have got. I think we should rather improve upon it, and the jurisprudence in this particular area is building up.
I don't think anybody is suggesting we throw it out. And don't take my position. My position is meant to provoke the kind of discussion we are having. Because what I said is that it should never have gotten there, and I don't want to change my position on that. Because I think from 2001, we've had the opportunity to do something. But more importantly, what I'm hearing from both my eminent jurists is that maybe my position is too violent. It's important that I'm very, very concerned that we must never travel down this road again. But subjected to
we have a fundamental issue here.
Yes.
Nature abhors a vacuum.
Yes.
And the same with the governance of a country. Yeah. If you have the governance of a country and you have uncertainty at any particular point of time, it is not good for the society. So we agree, even at the time that we are talking about, if there is an election petition and the elections give enough time, like in the Bush situation, for the matters to be determined earlier, that is the best situation. Nobody is saying that it is good to have a situation whereby Article 64(2) of the Constitution will be resorted to. I'm looking for a situation whereby we can deal with election petitions and complete, so that Article 64(2) become otious. But unless we do that, let's not...
No, I'm not. I'm not. We are not throwing the baby out of the bathwater. No, the bathwater is warm enough. But Justice, you've virtually written all our Constitution. Tell us, from your experience, the kind of concrete things we need to do to be able to satisfy fairness, equity, but also rationality. The rationality that we must determine these things and then sway whoever comes out of it. How do we do it?
We have given you the answer.
Yes.
And the answer is, and I'm going to repeat it again.
I want it repeated because it's important.
Repeat it again. The Constitution provides that you elect the president within 4 months before his term of office ends. If you did that, and there are challenges, the challenges will be finished before the next president is sworn in.
That's right.
It's simple as that.
So let me take
Now, let me finish. Okay. Then the politicians agreed that we should do it with the parliamentary election. It is doing it with the parliamentary election that is giving us the trouble. Okay. The Constitutional Review Commission has reviewed that aspect of the matter. Ghanaians have anticipated, as it were, what we are discussing now. And therefore, the Review Commission has recommended, and government has accepted, that the Constitution should be amended so that the elections, both elections, are held in November. So you have sufficient time to deal with the matter before the swearing in. Excellent. So the answer is already on the table.
We are making progress. But my problem here is this. The government that accepted it is dead. In the constitutional dispensation, I believe constitutional changes are driven by the parliamentary process. What specific steps should we take now to revive the recommendations of the CRC? Fortunately, the same government is in power. But more importantly, as I understand it, correct me if I'm wrong, in constitutional times, it is Parliament that drives the change process and not the executive or anybody else. So, Gabriel, I mean...
No, let me explain that.
Correct it for me.
Let me explain that.
I thought it was Parliament
the thing about our Constitution is that there's a provision for amendments. Amendments to the Constitution is done through the introduction of a bill in Parliament. And that bill, normally under our constitutional dispensation, is introduced by the executive.
Not normally. It can only be done by the executive because the only people who can charge money onto the Constitutional Fund of Ghana is the president. Yeah. So it's not normal. That's the dictatorial remit of our constitution.
Yeah. So what happened in the last government was that the executive, before coming in terms of with a bill to amend the constitution, decided that let us give the people of Ghana an opportunity to express their views.
Yes.
So those views were expressed. The Constitutional Review Commission came out with recommendations government has accepted. Government is a continuum. So even if there were to be a change of government, what was decided and what was taken by a white paper by the previous government will still be a product of the government of Ghana. And what we are expecting is that, like we are saying, thank God that we still have the same government. So
you think God did that?
So it would be a situation whereby the report would just have to, the necessary steps for implementing the report would be taken. As I said, if another government had come, it would have done the same thing. It would have gone ahead to implement the provisions of the Constitution.
I think I'll add up to what Gabriel has said. In addition to just issuing the report, the Constitutional Review Commission was careful enough to add draft bills which would be needed to implement the recommendations. If I'm right in saying Gabriel was the chairman of that committee.
Yeah, the drafting.
So when the report came out, the necessary bills which would implement the recommendations of the Review Commission were attached to the report. I believe I'm right in saying this, that the government, I believe it was the leader for parliamentary affairs, who said fairly recently that steps are being taken for the relevant bills to be brought before Parliament. So the process has, in my view, already started, so that the proper thing is done as far as the Constitution is concerned.
Good. I'm glad we are ending on a very, very positive and pragmatic note. But I think from where I sit, and from the perspective of the people of Ghana, whatever needs to be done must be done ahead of our 2016 election so that we never, ever have to put ourselves in this position again. So in the words of you two very eminent jurists and men of the Constitution, what you've said is that Tarzan's take has been violently put. Maybe it means well, but I think in putting it violently, we've extracted at least the basis for moving forward. And I think the most important thing in this whole thing is we should never sacrifice the equity. Yeah. We should never sacrifice the fairness. We should never sacrifice, if you like, the framework and the context from which our laws flow. Correct. But it is important and agreed by every Ghanaian living everywhere that never again must we find ourselves in this situation. So whatever it takes, and I'm very glad that Uncle Okoto is still alive, almost 90. Gabriel is here, is fit and strong, and I hope that out of this discussion, all of us can drive this process so that we get this thing sorted out ahead of the 2016 election. As we say in my part of the world, they said, what is gone, let it go. But the future is more important to us. And I'm assured by what you have elucidated tonight that if we do indeed move, and move quickly, then I think that we can avoid all of this situation again.
We've always been sensible in Ghana. I think we will continue to be sensible.
Just by way of concluding, I think let me say something about the parliamentary elections. The Constitutional Review Commission also addressed the Adote case matter, and the recommendation was very specific. That the recommendation was that the Chief Justice should establish a special division of the High Court to deal with parliamentary disputes after the elections. Said that there's a division of the court and it will handle only those matters. And our recommendation was that they should be given a time limit of maximum 6 months from beginning to delivery of judgment. And if that is done, then people will come to realize that when you have an electoral dispute, it is good to take it to the court. And that is important to strengthen the constitutional dispensation. We think that way we are striking the balance between expediency and fairness, as I have said, as the challenges which have confronted all other countries on this aspect of the matter.
Well, thank you very much, Gabriel. Thank you very much, Honorable Justice. There you have it. Let me finish off with a moderation of my take. I still hold to the view that something should have been done earlier than this. But it is part of the style of this country that we are excellent at managing crisis. We are useless at preventing crisis. So that the crisis is upon us, I'm very glad to hear that my two guests have given us hope. But let us not, like the Doomsday crisis, go to sleep after the matter is determined. Let us keep pushing. 2016 is not too far away. And if out of this experience we are able to avoid this, but allow fairness, equity, and the pragmatism of Ghanaians to ensure that we get the process the right way around, that petitions are held and decided before the rightful owner is sworn in as the president, legitimacy will be restored, peace will reign, acceptance will be fine, and Ghana will continue to make progress in our democratic governance. Thank you very much for watching us tonight. It's been Tarzan's Take.